Okay, we have our third and final case of the day. 22-2487, Heritage Property and Casualty Insurance Company versus Moss. Counsel, ready to proceed?
Yes, Your Honor. Good morning. May it please the court. Kara Lake on behalf of the appellant. I'd like to reserve 2 minutes for rebuttal. To borrow from Judge Jay's comment in a prior oral argument this morning, words matter. So the question before this court is, did the Supreme Court in Roe, when it said that a trial judge must determine the results obtained and whether there was limited success or the extent of success when determining a lodestar, did they mean must? And submit to this court that because the trial judge did not, that the final judgment for fees must be reversed. The facts of this case are very straightforward. It was a property damage, another first-party property damage case. My client, Heritage, paid on the claim several times, then went to appraisal, so coverage was not in dispute. And they paid an additional amount in the appraisal case. As a result of that, there was a bad faith lawsuit filed under 624.155. In the bad faith lawsuit, plaintiff's complaint was a somewhat shotgun approach. There was a paragraph in the complaint, it was 29. It was letters A through T. There were 20 different violations alleged against my client. Those got whittled down to 9. And then the trial judge, finding no evidence to support an additional 3, whittled it down further to 6. So when the case went to the jury for the bad faith case, there were only 6 questions on the verdict form. The jury found that my client violated one of those statutory violations. And that violation was in part due to my corporate representative who testified that Heritage at that time was a new company here in Florida, started in 2012, and did not have procedures in place for claims investigation. So there was a concession at trial. I understand there's an argument that it wasn't until trial, but there was a concession at trial, and that's why the jury found my client liable under that particular allegation and pleading. The plaintiff asked for over $50,000 in the bad faith case. The recovery was $5,250. It was a 10% return on that request. The fees that were subsequently awarded for the bad faith case, not for the underlying case, but for the bad faith case, were $272,000. That included a 1.5 multiplier. Heritage asks this court, we've issued, in the brief you'll see there are 4 issues, but primarily it really is the first issue. It really boils down to this court reversing on the results obtained factor that's set forth in Roe. It impacts the lodestar and it impacts the multiplier. In the terms of the lodestar, the Florida Supreme Court, and this has gone back, I counted it up while I was waiting for oral argument, I said, how long has Roe been around? It's almost 40 years. So this is not novel. And the Florida Supreme Court said when a party prevails on only a portion of the claims, not counts, claims made in a litigation, the trial judge must evaluate the relationship between the successful and the unsuccessful claims and determine whether the investigation and the prosecution of the successful claims can be separated from the unsuccessful claims.
Well, counsel, let me ask you this question. Let's
Sure.
say that there's a 1-count complaint.
Yes.
And the result that is sought is fairly modest, and the result obtained is fairly modest.
Mm-hmm.
But the defendant in the case makes it, nuclear war.
Right.
It's everything is obstructionist, and I'm not suggesting this is such a case as that. So the defense is taking a mundane, straightforward, modest case and inflating it into this big battle.
Correct.
So the attorney's fees obviously are much higher,
Right.
because of that defense posture.
Right.
Why wouldn't the trial judge in that particular case take that into account and say, of course, ordinarily this would be a shocking amount of fees,
Right.
given the result obtained, but given the defense's posture, it seems reasonable.
So, Your Honor, they can. And Quanstrom, Florida Supreme Court, said exactly that. Said Quanstrom cited the Palma case from the Supreme Court, which this court recently addressed in, I think it's Baker. So Palma and Baker were PIP cases. And we know that Palma was a nuclear type of case, right? The Florida Supreme Court said, I think it was the 4th DCA said that State Farm went to the mat on that case. The reason they did that, the reason the case got nuclear, was that PIP is such a widespread issue for the state of Florida.
Didn't the trial judge here make a similar suggestion that Heritage went to the map?
He did, and the great question, and thank you for asking. In the original final judgment, there wasn't even a reference of that whatsoever. The results obtained is missing in the original final judgment.
But someone asked the judge to look at that.
Right.
And he did.
Heritage moved for reconsideration and said, you missed this very essential
And
element.
through the bookage.
And he said, okay. And so then this court can look at the record. And there is no competent substantial evidence that Heritage looked at this like the Palma case in PIP, where it was a $600 thermogram, or the Baker case before this court, which was also a PIP case. Heritage did not look at this case and say, oh, it's going to be widespread impact. Was there a shotgun approach complaint with 20 violations? Yes, there was. But this was not such a novel and a nuclear case for the client, for the insurance company, that it went to the mat. There was struggle with, I think, Judge Sound, I think you're going to ask me a question about the orders and compelling depositions and some discovery Fred, I would call it. Absolutely. I read it and I saw it, and yes, does it look fun on either side.
It's
actually.
years long.
I'm sorry?
It's years long.
Yes. I think the case was pending 3 years. But on both sides, quite frankly, this is not illegal, but a professionalism standpoint, you say, oh, I'm asking for depots, they should be given. You shouldn't have to file a motion to compel for depositions of the lawyers and disclosure expert. If you're coming up to a fee hearing, a week before, and that goes to the continuance part. But this was not a PIP case that had widespread antenna or octopus legs across the state of Florida for Heritage. It was a one single coverage admitted, go to appraisal, pay more money, and then go to a bad faith. This is a small trial. This is not a week-long or 3-week-long medical malpractice case. This is a simple statutory bad faith case. What makes it unique in this sense is that the plaintiff asked for so much, $50,000, got $5,000, and the attorney's fee is 40 times the recovery made by the client. The results obtained in this case should have been reviewed by the trial judge in the context that this was not a good recovery. Competent substantial evidence comes from the plaintiff's own expert, Mr. Dyer, who testified that the result was not stellar. He actually, Judge McCarr, you said modest in your hypothetical. The expert testified for the plaintiff that it was a modest recovery. This was not a stellar result. It was the results obtained absolutely require the trial judge to look at what the Florida Supreme Court said he or she must do, and that is to determine if you can separate the relationship between this one claim that the jury found my client liable for and the others that you didn't prevail on. That wasn't done, and the case isn't a Palma case. Although the judge cited Palma and said that Heritage went to the mat, there's no evidence of that, other than the discovery dispute about the depositions, which is regrettable. I can suggest by both sides should have occurred. In addition, the multiplier. So after Roe, Quanstrom comes along and talks about the multiplier. Quanstrom reaffirms Roe, reaffirms the factors that are embedded in our Code of Professional Responsibility, and it talks about 3 factors to determine whether a multiplier should be applied or not. The first is the relevant market, whether it requires it to obtain competent counsel. And on that particular issue, it is interesting. I told my good friend and colleague, Mark Nation, to stick around because he's going to come up during oral argument. The testimony before the trial judge was that there are other lawyers who would take first-party property damage cases like this one without a guarantee of a multiplier. What was lacking, which was the plaintiff's burden, was any evidence that their expert canvassed or surveyed lawyers and said, would you represent Pamela Miles in this case where Heritage has admitted coverage, made payments, gone to appraisal without a multiplier? Mr. Dyer didn't do it. He said he spoke to 2 lawyers, didn't talk to them about this case, and then also admitted about Morgan & Morgan and Mark Nation handling cases in the relevant market area, Brevard County. We submit to the court that the relevant market area does not have to be limited to solely Brevard County, but could be Central Florida. And we draw upon the Florida Supreme Court case Sunbank versus Ford for that proposition. In 1990, the Florida Supreme Court, talking about the Quanstrom multiplier, said that you need record evidence that without an enhancement, the plaintiff would face substantial difficulties obtaining counsel in the local or other relevant market. So there was testimony and evidence that, in this case, that there were other lawyers who practice in this area, practice first party, and could take the case.
Counsel, if you could spend a little bit of time on the statutory argument about 627.70152.
Okay, yes, thank you.
8C.
So this is interesting. In talking with my colleagues before oral argument, the legislature changes this area of the law and then changes it again. And so we are caught in an area where at the time of this hearing, this statute was in effect. 627.70152 existed, was effective May 26, 2022. And at the time of the original final judgment in August, and then just a few months later, the amended final judgment, that statute was still on the books. What that statute did was it disapproved of Joyce, right? Joyce said, we're not going to follow federal standards on the rare and exceptional circumstances for a multiplier. And the legislature enacted the statute and said, no, we are. Florida will follow the federal standard. And 8C says that there's a strong presumption that the lodestar is sufficient and reasonable. The plaintiff has the burden to rebut that you get a multiplier only in rare and exceptional circumstances with evidence that competent counsel could not be retained under reasonable circumstances. So
Is the date of the entry of the judgment and amended judgment the relevant date for consideration of applicability of that statute?
Yes, Your Honor, it is. It is. And so
Under Florida law?
yes, so writing this opinion, I prefer the opinion be written on the results obtained issue, but this statute, that statute, subsection 8C, does not exist in that context. There is a new statute, though, in effect as of March, that now pulls back that rare and exceptional. So it's back in the law, the body of Florida, and that is 57.104, subsection 2. Exact same statement about the presumption, the lodestar, sufficient and reasonable, and you only get a multiplier in rare and exceptional circumstances. So it is the law still currently. It just will be confusing if written, potentially confusing. I think this panel would write it very clearly. But
Is the right to attorney's fees a substantive right?
that's a great question, and the retroactivity issue is in play. The Menendez case, and then there are other courts recently interpreting the retroactive argument. I think there's a case on the 4TCA, but we haven't cited it in our briefs.
So is it a substantive right? Is the right to an award of an attorney's fees a substantive right?
I would suggest yes, but not the lodestar. And the lodestar is considered different. I think we have identified a case, and I can't recall it, I apologize, in our reply brief to this point. But it's certainly in this scenario, this court doesn't even have to look at whether there's a retroactive application or not. This statute was in effect. It did apply to this case. You'll hear that this was a 624.155 fee. However, both the complaint cites both the 627.428 fee, which triggers this statute that we're talking about, insurance fee statute, and 624.155. The final judgment, the amended final judgment, cites both statutes. It was an and or. So it is an applicable statute in this case. It would remove the multiplier. I think I have covered everything that I have in my notes, unless the court had questions for me.
What do you make of the Menendez decision in 2010 from the Supreme Court that says The statute in effect at the time an insurance contract is executed governs substantive issues arising in connection with that contract.
And Menendez is coming up all the time in many of these cases.
Are we free to ignore Menendez? I think that outcome's obvious.
No, you're not free to ignore
So
it.
has the Supreme Court not articulated to us that the relevant question in determining the retroactive application of this statute is when was the insurance contract executed? Not the date of the entry of amended judgments, but when was the contract executed, and the statute in effect at the time of the execution of the contract governs substantive issues.
That's a great question. And I have to add, the multiplier is not in the statute. The multiplier is a judicially engrafted add-on, right? So when you ask the question, Your Honor, about whether it's a substantive right, and I answered you candidly, yes, the fee is, the statutory fee is. The multiplier is not. It is a judicially engrafted add-on. And what's really important about the multiplier is it is based on one of the factors, results obtained. You won't know whether you have a multiplier scenario or not until you go through the trial, until you go through the trial. So at the time of this final judgment and when the judge is signing it, that statute was applicable and should have been applied by the court. And it's the current law in Florida today. So this court would be well suited in relying on that and noting that change and shift in our law. And I ask that you reverse and remand. Thank you.
May it please the court, Matthew Struble for the appellee, and we would ask this court to affirm the final judgment, which is based on substantial competent evidence in this case. The fee hearing, which is what brought rise to the final judgment in this case, was supported by testimony from the trial lawyer, being myself, as well as a fee expert, a local fee expert, Dave Dyer. The trial court considered all of that evidence. He also considered the fact that on the other side, the defense didn't call a fee expert at all. In fact, the only person they called was the defense attorney who had defended at Heritage in the exact same case for 6 years. If you look at the final judgment, the trial court detailed that. Obviously, it's for the trial court to weigh testimony, credibility, and the court properly noted the fact that Heritage in this case didn't even call a fee expert to oppose the claim on the fee hearing. The trial court, in its 13-page final judgment, considered all of the factors that it's supposed to consider when making this award. That included the results obtained. If you look at page 11 of the final judgment in this case, the trial court explained that it considered the results obtained when it issued the award. It explained that one count was pled and that the plaintiff prevailed on one count. It also talked about the State Farm versus Palmer case and talked about how it was the defendant that caused any inflation of the work that needed to be done in the case. That's more than supported by the facts of this record, and it's detailed in our brief. As you see, throughout 6 years in this case, Heritage concealed the fact that it had no guidelines at all. It concealed the fact that it owned the company that was supposedly an independent company that it had under the Contractors Alliance Network. And as a matter of fact, after 6 years of ordering them to produce documents, they produced one that was not dated. When they finally produced somebody to appear for deposition, they still omitted the fact that they had no guidelines at all. They produced at that deposition an undated one, and it was only during trial, by chance, that it came out that at the time they adjusted this claim, they had no guideline whatsoever. And it was during this trial, by chance, from a question from a juror, that it was revealed from the juror picking up on it that they actually owned these companies that they were calling independent throughout the 6 years of the case and throughout the trial. So without the trial in this case, Heritage never would have admitted the fact that it had no guidelines at all. The jury entered a verdict in the plaintiff's favor in this case based on that, finding that the insurance company had no guidelines and because of that failed to implement proper standards for the adjustment of claim. In addition to that, you look at the evidence through both. We can look at the one witness that the defense called. According to the defense's own testimony, they could not list a single lawyer throughout the entire state of Florida that ever tried a first-party bad faith case as it relates to property damage. the evidence from the fee hearing was that this was the only time a final judgment has ever been entered based on that bad faith statute as it relates to first party claims. So when you look at whether the court was within its discretion, it certainly was. It was also well within the law that applied at that time. They didn't even argue this, but I'll touch on this, but it's clear that retroactive application doesn't apply. And even if somehow it did, as I put forth in the brief, even if somehow they had a time capsule to make that law go back 8 years, they would have to prove it wasn't a rare and exceptional case. And based on their own testimony from their own witness, it's the only case they're aware of in the entire state that there's ever been a finding that an insurance company violated that bad faith statute in a first party claim.
Why did the litigation take so many years? I'm trying to get my arms around that. I'm a litigator in my past. But I look at this case and I think, well, how could 6 years pass and all this attorney time?
Yeah,
One statutory violation, not disclosing policy.
absolutely. I would, further record, you can see from some of the testimony from the fee expert talks about how I try cases all the time. The first thing I do is I notes from trial, try to get to trial. I would reflect on what the various court orders. They were sanctioned over and over again to produce stuff that they never produced. As the court said in the order and during the hearing, we weren't seeking discovery. We sought one deposition in this case. We proceeded to trial after obtaining one deposition in this case.
Was it the same trial judge?
Trial judge did change throughout. But ultimately,
How many judges had this case on the docket?
I'm sorry?
How many different judges had
How many different judges? I would guess maybe 3 judges, 2 to 3 judges over the course of the docket for sure. And then obviously, the fee hearing issue has been pending for another 3 years as well. So that's why. But if you look at it, the court over and over again awarded sanctions. As I talked about in the hearing, I never sought those fees. I never recovered those fees because it didn't move the needle for my client. But they were sanctioned over and over again to produce these things, which they never did. And as I alluded to, when they finally sat down after years for a deposition 2 weeks before the trial, they still didn't admit the fact that they didn't have those guidelines. That just came.
They were sanctioned. What kind of sanctions are we talking about?
Monetary sanctions for all the time we were putting in to compel them to produce records and to produce somebody for a deposition. I believe the deposition, their corporate representative was scheduled 4 or 5 times. They never appeared. The person they finally ended up producing happened to be a gentleman by the name of Mr. Bates, who had just been with the company for about 3 months, something like that. So they ultimately produced somebody. The person they produced who had the most knowledge was somebody who first became involved in the company several years after all of this happened.
What were the attorney rates based on? What year? Was it based on 2016 rates or 2018 rates or 2020 rates or 2022 rates? Or
Yep. So the evidence was that. So if you look at the rates there, I was awarded 425. My associates were awarded 300. We had about a dozen orders where we had been referenced stat rates years prior. So it wasn't our current rate, but we just basically moved for the rate that we had been already awarded in the past several years prior. So it was generally in line with rates that we had been done in years in the past. What the case law says on that is
so you waived prejudgment interest.
I did, because there is case law that says that the trial judge can award current rates. It wasn't a current rate, but it wasn't also a rate going all the way back. So we waived prejudgment interest to alleviate just having to deal with all the calculations related to that. So when you look at all those things, it certainly was. And as to the rates, I testified to it. We had dozens of court orders in the same jurisdiction awarding us those rates, as well as a multiplier. So to talk about that briefly, whether it's, as I indicated, it doesn't matter if the marketplace in this case is Brevard County or Florida, because according to them, this was the only case they've ever heard of that's resulted in a bad faith first party verdict in Florida. And I'm the only plaintiff firm they could identify that's ever handled such a case that far.
Do we need to address the statutory issue?
I would say not for the reason in the brief, which I'll touch on. First of all, it's clear that it's not retroactive. The first statute they're talking about came in effect May 26, 2020. That's about 7 years after the contract became in effect, and that is the determinative issue. Several years after the lawsuit was filed, it's even after the fee hearing and after a judgment was initially entered in this case. So it's long after all those things, so it need not be considered. The other reason why it need not be considered in this case, if you look at there was 2 fee statutes at issue. There was 627.428. However, there was only 24 hours requested related to that statute, and that was for the underlying time. The court did not award any of that time. So 627.428 is not an issue at all. The operative fee statute in this case is the bad faith fee statute, 624.155. And that bad faith fee statute, as we talk about, that hasn't been affected by these various statutes. The statute that is at issue about potentially being applied retroactively, that retroactively only applies as to 624.428, which is not an issue in the final judgment. The final judgment only involves 624.155. And I just want to point out that in addition to the Menendez case from the Supreme Court, which makes that clear, we cite to a case State Farm versus LaForte, 658 SO.2D 55. That is from the Florida Supreme Court as well. And that court held and that was actually involving 624.155, the bad faith statute. In that case, the Florida Supreme Court held that a statute cannot be applied retroactively to affect a fee claim that's issued on that bad faith statute. So there is, the retroactive arguments don't even apply to the statute that's operative here. And in addition to that, the case law is clear. It can't be retroactive. In addition to that, so the Supreme Court has held that it can't be affected retroactive as to the bad faith statute. For those reasons, we think the final judgment should be affirmed, including, as I indicated, all of the evidence was considered, all the factors were considered, including the dozen that they haven't talked about, which the court details in its judgment in great detail, and clearly results in the final judgment being supported by substantial competent evidence. So for those reasons, we think it's clear that the final judgment issued by the trial court in this case should be affirmed. Thank you.
Very briefly, wanted to reiterate that Roe talks about claims, not counts. So it's irrelevant that the bad faith lawsuit was a one count for bad faith, statutory bad faith. It had claims that were 20 in number. And Roe said that the judge must evaluate the claims that are made in the litigation. And that requires the reduction of the lodestar and the removal of the multiplier. This case is not the case before this court, Baker, where it was Judge McCarty wrote a special concurrence in that opinion. It involved $1.48. And so that was coming on the heels of PAMA and the $600 thermogram. This case did not involve such a paltry sum that the insurance company went to the mat on some type of policy issue. Another point.
Well, you haven't challenged paragraph 34 of the trial judge's minute order.
I'm sorry, paragraph 34.
Which it says, it appears that Heritage decided to go to the mat over relatively small claims. And I mean, it basically goes on and on. So, the insurance counsel did not inflict the small cases, a larger one. This protraction resulted from a stalwart defense. And you haven't challenged any of those.
Well, I would submit that we have in our briefs, and we have stated that this was not something, although I conceded with Judge Sal that there was regrettable orders and some issue with regarding to scheduled depositions. It's not like this was a scorched earth where there's one case out of the 3rd DCA where the insurance company made the lawyer go up and down the East Coast taking 27 depots or some ridiculous amount. That's not what this was. To answer your question, Judge McCart, I also wondered how long or why it lingered so. And what I did see was a tremendous amount of stagnation where the case just sat. And I don't know why, because I wasn't trial counsel, but it was dormant. So that doesn't mean, though, that it's a PAMA or a Baker case. It doesn't mean that there were 27 depositions, or else you would have heard about that. My client did not go to the mat on this case. There's no evidence that this case caused Heritage to implement investigative standards. That is a leap that is unsupported by this record, and I wanted to make that clear. There was testimony that investigating standards for the claim did not exist at the time this claim was opened in the new company Heritage, and that as of 2018, the corporate rep testified that they do now exist, but there's no linkage. The temporal linkage is a leap that's not supported by the record. Both statutes are at issue, both 624.155 and the fee statute, 67.428, which triggers the statute about rare and exceptional circumstances. Interestingly enough, And I'll leave on this note, the legislature has changed the bad faith statute and added 64.1551 so that in this case, we wouldn't be here today. When an insurance company pays an appraisal award, that is not evidence of bad faith to bring a bad faith action in the ensuing fee claim. So I think that's probably why there's so much litigation going on in these areas, but I would ask the court to redirect to the Roe and Quanstrom factors the results obtained issue and reverse and remand for consideration of reduction as the Florida Supreme Court suggested in that. Thank you.
Well, thank you both for your arguments, and we also, of course, thank the Fourth Circuit for hosting us to have these types of events, these types of arguments here in Jackson. We appreciate council traveling here. We very much enjoy, as Jacksonville judges, to be sitting in our hometown. And if you could join the lawyers and the judges for the luncheon today, luncheon room, I hope we can do so. With that, we will be in recess.
All right.